Okay, so I make it 12:30. I can see that we've got quite a few people already joining us on the webinar, so we'll make a start. So welcome everybody. I'm Rebecca Phillips. I'm the professional lead at the Planning Inspectorate for Planning Appeals, and I'll be chairing the session today, which we are recording. This is the fifth webinar in our series. We've done some others that some of you may have joined us on, and this aims to engage with and share learning with stakeholders right across the planning system. Do visit our website to view our other webinars in the series and to sign up for alerts for future webinars coming up. The purpose of this session is to focus on public rights of way and share best practice on participating in the different procedures. In a moment, I'm going to pass over to our presenters, which is Heidi Cruickshank and Harry Wood, to introduce themselves. And we also have Annie Owens, an operations officer in our rights of way team, who'll be helping with your questions. For the Q&A, please feel free to put forward your questions through the session, including the Q&A feature in Teams, and we'll work through those after the presentation. We may not be able to get through all of them today within the allocated time, but we will do our best. Please use the upvote button as well, which looks like an upward arrow, and that will push any questions you like to the top of the list. The purpose of the session is to give advice and guidance on the procedural aspects of the areas of casework, but for obvious reasons, we won't be able to discuss or answer any questions on live cases. Okay, so with that, I shall pass over to Heidi.
Thanks, Rebecca. Hello, everyone. I'm Heidi Cruickshank, and some of you will know me. I've been an inspector for more than 20 years, working primarily in this area, rights of way, common land and coastal access, but I've also been involved with nationally significant infrastructure projects and compulsory purchase order cases, for example. In this area, we have an amazing dedicated team in the office and out in the field, and we all want to do our best to ensure quality outcomes. This webinar is intended to help you to help us by understanding our processes, and we will be happy to hear from you where the pinch points are and what we can all do to improve the service for everyone. We are specifically talking about rights of way cases, as Rebecca mentioned. So that's definitive map modification orders, often referred to as DMMOs, which are made under the Wildlife and Countryside Act 1981. Public path orders, or PPOs, which are made under the Highways Act 1980 and the Town and Country Planning Act 1990. So if you're here for anything else, sorry, we're not talking about it today, but let us know if there's something you want us to deal with in the future. So I'll pass you over to Harry. Thanks, Harry.
Thanks, Heidi. Hello, everyone. And as others have said, thanks very much for joining us today. My name's Harry Wood. I'm the operations team leader in the Rights of Way and Common Land Decisions Service. What this means in practice is that I manage the administrative team in this area, looking after a team of case officers and operations officers working across public rights of way, common land and coastal access casework. Prior to joining the Inspectorate just over 2 years ago, I worked in the rights of way service of a local authority, and I've previously worked in academia and in the charity sector. I work closely with Heidi in her position as professional lead, so I'm delighted to be able to join her today in presenting this webinar. The plan for today is for Heidi and I to present for around 20 minutes, perhaps a little longer, but not much. So it should allow for plenty of time for questions. So as set out in this slide, we're going to focus on best practice for preparing for and participating in the opposed order process. We'll cover initial submissions, including the role of the order making authority, or the OMA, as we sometimes refer to it, in referring unconfirmed orders to the Secretary of State. We'll then consider what happens next, exploring how the Inspectorate validate these referrals, why particular procedures are suggested, and the rules that govern the exchange of submissions. We'll then come to events, so how hearings and inquiries work, what those participating in events should expect, and in particular, how they should look to present their evidence. And then finally, we'll discuss the decision. So we'll distinguish between interim and final decisions. We'll highlight where decisions are made available, and we'll also explore a bit about how decisions can be challenged. Okay, so I'm going to pass over to Heidi now for this next slide.
Thank you. So one of the things that we would like to see and require from order making authorities when they're submitting an order is the relevant copy of the current definitive map and statement. So the definitive map and statement is literally made up of two documents. There is a map, and that will show the route and the status of the route in question. And there is a statement which holds particulars of the width or position of the route. The DMS is the official record of public rights of way, and it was drawn up initially under the National Parks and Access to the Countryside Act 1949. So earliest maps will date from the 1950s and may look as you're seeing on screen now. However, the definitive map and statement is made up of not only the original document, but also any orders which have been confirmed since the relevant date of that document. Subsequently, you may find more up-to-date maps which have been consolidated with those confirmed orders, and we will often see working copies of the definitive map and statement which authorities are using to see what is happening on the ground. Surveying authorities hold the DMS, and they are the ones who are responsible for the continuous review to ensure that it is up to date. They may also be, and usually are, to be fair, the Highway Authority. They may also be the Planning Authority and the Order Making Authority, although obviously these functions can sit within other councils where you have two-tier councils. So having set out the importance of seeing the DMS, I'm going to turn to Harry to tell us what else we need to see when the order is first submitted.
Thanks very much, Heidi. So this slide concerns what we call the OMA checklist, and this is a document that's made available on gov.uk on the Planning Inspectorate's page, and it's designed to guide local authorities when they are preparing to refer opposed orders. And we wanted to refer to it in some detail today because it's very important from our point of view that order making authorities follow this document as closely as they can. So just to go into a few details, you can hopefully see on this document, so the image on the right hand side, there is a column doc.ref or document reference, and this gives numbers for each type of document that order making authorities are required to submit. Now, these submissions can involve a very large number of complex documents, and so it really is important that OMAs use this reference system when referring orders to the Inspectorate. It's also important that documents are saved individually, or in other words, each document is saved as a unique file with the relevant document reference number. Now, you might wonder what I'm talking about here. Well, we sometimes receive submissions from order making authorities and indeed from other parties where a large volume of documents has been put into one document, so say a very long PDF or a very long Word document. And it can be extremely time consuming for our case officers to deal with this, as those documents do need to be extracted into separate files so that the inspector, the nominated inspector, can deal with them accordingly. So in some circumstances, we do in fact return submissions of this sort to the OMA for correction, but clearly this is ideally avoided as it can cause significant delays. And then I would also reiterate how important it is that OMAs follow this checklist all the way through to ensure that all necessary documents have been submitted. And it's worth noting that, so Heidi earlier mentioned the different statutes that you might be making an order under, and the documents required changes depending on the type of order involved. So for example, for orders made under the Town and Country Planning Act, any associated planning permissions will need to be included. Likewise, orders made under the Highways Act will need to include copies of the relevant rights of way improvement plan. So another thing we were keen to draw attention to with order making authorities in mind is that sealed orders, so the opposed orders we're referring to, do not need to be in hard copy. We accept, indeed we prefer, digitally sealed orders, and here we have an example kindly provided by Essex County Council. The OMA checklist that I was just referring to has recently been updated to emphasize that this is our preference, but I should reiterate we have accepted digitally sealed orders for some time. But it's very important to be clear that OMAs must send the original document to the Inspectorate. So what I mean by this is if the order was made on paper, then we do require 2 copies in duplicate. But if the order was made and sealed digitally, like this example we have here, then we can receive it via email. We can't accept a photocopy or a scan of a paper order. So just to reiterate, we can only accept the original document in the format it was made. And Heidi, do you have anything you'd like to add here?
Yeah, I just wanted to talk about when you're submitting orders, how helpful it can be if you have orders that are near each other, then to submit them at the same time means that we can be sensible about our resources and send one inspector to do 2 or 3 site visits or an inquiry and a site visit at the same time. Obviously, understanding your own resources issues, it might be that you're limited to sending one order at one time and one at another. But if you know then that something else is coming to us in 2 or 3 months' time, again, if you can let us know, that can be really helpful just to make a plan to make things work better for everybody, really. So just bear that in mind if possible.
So what happens next? What happens when we receive these submissions? Well, the first step is that we register a case on our case management system and create a case reference number. And it's likely that some of you have seen these before. They begin ROW, standing for rights of way, / and then are followed by 7 digits. We then go through a process of validating these submissions. Now, our case officers and operations officers are generally looking out for several things here. So, for example, checking that the order has been correctly drafted, that the correct notation has been used, that it's been made under the correct subparagraphs of the relevant legislation. If there are errors of these types, then the referral will be rejected. Now, this happens fairly infrequently. I think so 24 to 25, that is last financial year, only 2 orders were rejected. But nonetheless, such situations are clearly regrettable given the knock-on cost in time and money, and the need, not least because the order making authority will need to remake and re-advertise the order. Heidi, I'll pass over to you at this point to talk about procedure.
Yeah, so we are primarily talking about inquiries and hearings in this webinar, but please do remember there should be a good reason to ask to be heard. The need for cross-examination is more likely to arise where there is live evidence to be tested from users or landowners in DMMO cases, definitive map cases. And we should all think carefully about the cost of the public purse, which can be significant. The importance of ensuring that your evidence is correctly presented and submitted to the stated timelines is just as valid when a case is being dealt with by written representations. And so do take on board what Harry is going through in terms of validation and the next steps in terms of timelines across all of our procedures. But we are obviously looking to ensure that we only take inquiries when we really need to do so, and when there is live evidence that does need to be tested is the most obvious situation for that. Other than that, then a hearing or preferably written representations can be entirely appropriate.
Brilliant. So this slide is to do with start notices, and you can hopefully see we've reproduced the template document the Inspectorate used for opposed order cases where we're holding an inquiry. The reason we've reproduced this is it's a really important stage in the process. The start notice is produced once the procedure has been decided, and it's circulated to all parties and published on gov.uk. And as you can see, it contains a lot of useful information, including the time, date and location of the inquiry, the contact details for the relevant Inspectorate case officer, and submission deadlines. And so you'll note here that the deadline for statements of case is within 8 weeks of the start date. And similarly, deadline for proofs of evidence is 4 weeks before the date of the inquiry. Start notices also make clear that all parties must keep to the timetable set out and that late evidence will be returned. Now, there is a degree of discretion here, but we really can't emphasize enough how disruptive it is when late evidence is submitted, either before or during the inquiry. Sometimes this is unavoidable. So, for example, where evidence is only discovered after the set deadlines. But we would nonetheless take this opportunity to urge all parties to do their utmost to meet the deadlines set out in the start notices. Heidi, anything you'd like to add there?
Yeah, just to reiterate that the failure to submit your evidence in the times that have been set out can mean that it is rejected. If you're attending an event, you can ask the inspector to accept it, but be aware that we would be likely to consider this unreasonable behaviour. And if that gives rise to unnecessary expense, for example, due to needing to adjourn, then a costs award may follow. I have seen examples where people have found evidence the day before an inquiry, when in fact the whole case has been running and sitting with the council for 10 or 15 years. Clearly, there needs to be some sense about getting evidence in reasonable timescales so that it can be dealt with fairly for all parties. Public money is being spent in this public process, and it is important that we all behave responsibly in relation to that. So the first thing that we receive will be the order making authority's statement of grounds, and this can often become their statement of case. For everyone, the statement of case needs to set out your position in relation to the order. Do you think it should be confirmed or not confirmed? Are there modifications that should be made? And why do you say that? The statement of case is your opportunity to submit your evidence so that everyone has a chance to understand it and make their case in agreement or disagreement. If you intend to rely on case law, it should be submitted in full at this time. It is acceptable for additional case law with closing submissions should a point arise unexpectedly. However, in general, the statement of case is your opportunity to make your case clear to all. A good statement of case is to the point and focused on the relevant evidence to the specific route in question. If there is a matter on which different parties agree, it is useful to make that point at the time so that time need not be wasted on it. There's also no need to duplicate documents, so where a council has already put them in their statement of case, you can refer us to the relevant document. For example, see the Ordnance Survey map on page 32 of the council's statement of case. I say that this says. Sometimes an order making authority may act in a neutral capacity. For example, in public path order cases where the case is being made by the applicant, and sometimes in DMMO cases where, for example, they may have been directed to make an order. I would say to councils that if you believe an order should not be confirmed, then you can choose to object to an order. This is just as helpful and just as valid with the appropriate decision making within your own protocols, obviously. But when you are neutral, please bear in mind we may still require some information from you as the Highway Authority, for example. Where an applicant is taking the lead, we would ask them to adhere to the timeline of the order making authority, as otherwise this can lead to some delays in processing. For an inquiry, proofs of evidence will follow on and must not have any additional appendices attached. And remember that a summary proof of evidence is required if the original is more than 1,500 words. But cross-examination takes place across the whole proof, and that is set out in the inquiries and procedure rules. I will just quickly mention the matter of costs. In rights of way cases, most parties will bear their own costs. I would like to assure those who come to this only once that expenses will only be awarded where you have acted unreasonably and caused unnecessary expense. I would also like to make clear that we will highlight to you where your objection is not relevant by reference to costs. This should not be taken as a threat. It is intended to ask you to think about your objection against the relevant criteria to the specific order. If you are unsure, we would suggest you may wish to seek legal advice. Thank you. Harry, anything you want to add on that?
Yes, thanks, Heidi. I just wanted to mention that those of you who've previously been involved in the public rights of way cases with the planning inspectorate, which I dare say there's lots of people on this call, will be aware that currently the exchange of representations and indeed the submission of opposed orders from order making authorities is done via email, or occasionally some documents are submitted via post. Concerns have been raised by several stakeholders about the efficiency and the efficacy of this system, and we do recognise that it's not ideal. The Inspectorate more broadly is moving towards a portal system whereby all submissions are made via a website, whether you are the OMA, whether you are the objector, for all parties. And indeed, some areas of casework have already made this move successfully. And we're hopeful that our area of casework will move on to the portal system in the foreseeable future. And we're confident that this will significantly improve how the casework area operates. So I just wanted to mention that because we have received concerns about that in the past. Now, this slide is to do with documents that the Inspectorate will circulate. The reason we wanted to mention this is this is an aspect of the process that can cause confusion, which documents the Inspectorate do and which we do not circulate as a matter of course. The Inspectorate circulates statements of case and proofs of evidence to all parties, but we do not circulate any accompanying appendices. And this is because we are following the 2007 rules, and we've reproduced the relevant passage here. And these make clear that supporting documents should not be circulated by the Secretary of State. All documents, including any accompanying appendices, must be made available by the order-making authority. Some order-making authorities choose to create an online document repository to share these documents, and this is our preferred method wherever that's possible.
Thanks. So you will often find a case management conference, or CMC, held in relation to inquiries and sometimes to hearings. This is something that we are doing more often, having seen how helpful it is for our planning colleagues. This is just a pre-inquiry meeting and held virtually to deal with procedural matters, would normally be around about an hour or so. It is helpful if you're able to attend or ask someone to attend for you to assist with the smooth running of the event on the day. And really what it's doing is dealing with the matters that those of you familiar with these cases over the years will have been spending time at an inquiry dealing with first thing in the morning, and that wastes the inquiry time when we're actually together in person. So it is a chance to deal with things such as the availability of parties, whether the event needs to be a little longer than initially programmed, whether there are missing documents, those sorts of issues. To be clear, there will be no discussion of the case itself during the CMC, but as I say, it is really helpful if you can attend, and you will see them, invitations to those come out more often if you're involved in a case. Okay, thank you. Harry, back to you.
Brilliant. Thank you, Heidi. When an event is held, so when it's decided that a hearing or inquiry needs to be held, the Inspectorate's preference is always for this to be held in person. But in certain circumstances, virtual inquiries are necessary for operational reasons. What has caused some concern in the past is the extent to which order-making authorities are expected to be able to host hybrid or blended events. In other words, where parties can attend online or in person, depending on their preference. Now, we have issued a view on this in the past, but for clarity, it's only in exceptional circumstances that hybrid events are required. And there is no expectation from the Inspectorate that all in-person events should allow for people to also attend online. If local authorities wish to do this, of course, then that is at their discretion, but there is no expectation from the Inspectorate that this should be a standard. It's only in exceptional circumstances where we will make clear that hybrid functionality is needed. More detail about this can be found in our guidance on virtual events, and we'll share a link for this at the end of the slides. But I would advise you to contact your case officer if you have any particular concerns around this issue. Thanks, Pete. Would you mind moving on? Sorry, Heidi, did you want to come in there?
Yeah, I just wanted to say that one of the other things that you may start to see, and something we're doing more frequently, is that closing submissions, if we are meeting in person, it is not unusual for closing submissions to take place virtually a week or so later. That can be organised at the CMC, it can be discussed at the inquiry. It's just about making the best use of the time when we need to be together in person, and then making use of the facility that we have in order to hear those closing submissions and possibly cost applications, which can be done virtually. But that would all be planned in and you would know about it ahead of time. So just wanted to add that in. Thanks, Harry. Thank you. We can move on then to the next one. So yes, I was just going to talk a little bit about decisions. So we have tried to make clear more recently where there is an interim decision. So this is where there is a proposal to make a change to the order, which requires advertisement. So in the header of an order now, instead of simply seeing order decision, you will also see interim order decision as appropriate. And hopefully that will help people to just understand that that's not the final decision. Decisions are circulated to the parties to the case, and they're then also published on gov.uk so that you can access them. For those who are attending who are involved in planning more usually, just please be aware that if there is an error within the decision, then we cannot alter it, as the slip rule does not apply in this area of casework. Obviously, we will always do our best not to make errors, but we are human. These things do happen. Whilst the complaints procedure is not an avenue through which decisions can be changed, we do consider whether there are broader implications from matters that have been raised, and positive suggestions are always welcome. The only way to change a decision is by legal challenge, and information on that is also sent out to the parties who are in receipt of the decision. Just to mention, we've talked a bit about guidance and particular regulations. The links to those are set out at the end of the slides, and if you're an IPRO member, then it may be that they would be able to assist you with certain aspects of the whole process, so something to bear in mind. I'm going to return back to Rebecca now. I think we have some questions in the chat.
Yes, thank you, Heidi. Yes, we do have a few questions. They're coming in the chat. So you use the button to upvote them, as I said earlier. So the first question is, in what circumstances do you consider CMCs to be appropriate?
So I personally feel that they're appropriate nearly all the time, because it's useful to find out who is going to attend. It's an opportunity for people to know who is there on the other side. And we have had circumstances relatively recently where an event that was to be an inquiry, when we held a CMC, we found that those people did not want an inquiry, and there was no need for us to do. There are certain circumstances where we do have to hold an inquiry depending on the parties involved, and so we were able to change that to a written representations case. So I think that they are an extremely useful process, and I encourage inspectors to do that as much as possible.
Okay, thank you. The next question is, to what extent may an inspector refer to further evidence available through hyperlinks, where the core of that evidence is included in a submission? So, for example, a statement of case in relation to a DMMC may include a map extract showing the order way and its neighbourhood, but a hyperlink may give access to a much wider vision of the map. In that event, might an inspector still reach a finding on the basis that the inspector did not have before him or her the wider context of that map?
Okay, So I'm just reading the question as well. So
Yeah,
I've
it's
got
quite
it
a
in
long one,
front of
sorry.
me. It is, yes.
So I think what the questioner is asking, and hello Hugh, by the way, is inspectors, as we know, can only consider what's in front of them, but in certain circumstances, via the click of a button, there is more in front of them. Does the hyperlink mean that that evidence has been made available to the inspector, if you like? And apologies, Hugh, if I've misunderstood your question there.
No, I think that's how I read it as well. Thanks, Harry. So yes, I mean, obviously, in general, what must happen is that all the evidence must be available to all the parties. So the inspector is not seeking evidence or finding evidence themselves. And so I would say in this instance, a hyperlink may be fine, so long as we know that that hyperlink isn't going to change. So if it is a map, then it is unlikely to change significantly in the timescale. But I think it's something to be aware of. An inspector will concentrate on the hard evidence that is before them. And I don't think I can add anything further to that. It may be something we need to take away and think about even more to make sure we're giving the right advice to parties so that you know what you can and cannot submit. And that's across the planning inspectorate. That's not just in this area.
Thank you. So the next question is, where an OMA is adopting a neutral stance and the applicants or supporters are not able or willing to take on a primary role in support, how does PINS manage that?
That's probably one for you initially, Harry, in terms of how you deal with it in the office.
Yes, and how we would deal with it in the office is sort of hinted at in the question there, and hello as well, Will. There are circumstances in which an order making authority will adopt a neutral stance. And so what that means is ordinarily an order making authority will be supporting the confirmation of the order because, of course, they have made said order. In certain circumstances, they adopt a neutral stance. And what that means is there is no longer the order making authority there to be making that case, if you like, for confirmation. As Will suggests, what we would usually do if nobody has been forthcoming is contact supporters or other people who expressed support or made representations when the order was made to see if they can take on that primary role. In circumstances where nobody is forthcoming, that can be a little bit tricky. I mean, is that something you've considered at inquiry or hearing level, Heidi, or in written representations cases?
Yeah, so certainly where that happens, you basically have to make a decision on the just on the evidence that's before you. There's no one bringing the case forward. In general, we wouldn't look to hold an inquiry in such a situation because obviously that you would expect to have a party present in the inquiry, and so that would move to written representations unless there were legal reasons why we couldn't do that. And you just make the decision on the basis of the evidence that has been put before you, even if it is not argued as such. So no one has argued back, which may give another party an advantage effectively.
I would say it's relatively rare. Yeah. Not that cases are that OMAs are neutral. That does happen. It is not. Most of our cases, OMAs are not neutral, but it does happen. But it's rarer still that there's no party willing to take the case on.
Yeah, I think I'd agree with you on that, Harry. I think that most applicants are motivated to be involved. They've often seen this through from a very early stage and will be involved. And that's particularly the case, obviously, in public path order cases. Then that's very much the case. That would be very unusual that they weren't.
Okay, thank you. Turning to another question that's been upvoted, quite popular. When the OMA has requested written reps, but other parties have requested to be heard, can PINS refuse that request on the basis that written reps is still a process which places a case in front of an inspector? We've had cases with finished or no user evidence and or with objections which we don't consider relevant, which haven't proceeded via written reps and instead gone to a hearing or inquiry because other parties have asked to be heard. And a follow-up to that, do such requests to be heard carry more weight than others, e.g. when made by a parish council or affected landowners? Thanks.
Thanks, Rebecca. So unfortunately, our legal processes at the present moment in time mean that we have to hear when someone asks to be heard. We will take whatever action we can to make the point that we consider it unnecessary to do so. And that may include during the CMC process to point out that this case can be made perfectly well by written representations. But we are in a position where we are unable to change that. In relation to the question about whether certain requests carry more weight, it's not quite that case, but where a local authority makes an objection, so they don't even have to make a request to be heard, they can simply make an objection or a representation to an order, and that's to a public path order, then we do have to hold an inquiry. So that is a slightly different situation. But in terms of the generality, just because certain party has asked does not give any further weight. It's just if any party has asked. I don't know if there's anything you want to add to that, Harry.
It might be worth just mentioning a bit about cost implications again, I think. And so I think it's very important to make clear that the right to be heard in and of itself is not unreasonable. It's there in the statute for a reason. Other parties may think that there doesn't need to be a hearing or inquiry, and indeed the Inspectorate may think so. But if you are of the view that there does need to be one, and then you exercise your right to be heard. And again, it's not in and of itself an unreasonable request. However, if then at the subsequent hearing or inquiry where you have engaged your right to be heard, you then do not participate in such a way that suggests the event was required, then you may need to be aware that there could be cost implications. I don't know if you want to elaborate on that, Heidi.
Yeah, and to be fair, we have had cases just in the last 12 months or so where someone asked to be heard and then didn't turn up at all, and we then gave costs against them. So yeah, that is a very important point to make. And I said earlier in the presentation, and I reiterate, that there is a cost to the public purse, whether that's to the planning inspectorate or to the council, and asking to be heard needs to be done proportionately and for the right reasons, and not simply because you feel that that's what you want to do and you want to have your day before an inspector. I can assure you that written representations are taken very seriously. The inspectors will read your written representations, and the decision will be made just as carefully as if you were there in person speaking at an event. So thank you. Thanks, Rebecca.
Thank you. The next one is a popular one. It is understood that OMAs aren't able to assess the validity of an objection beyond whether or not it is duly made. This means that even if the grounds are largely irrelevant, we are forced to create a full submission pack to get a decision on the relevance of such an objection. This represents hours of work for small and resource-poor teams in OMAs. Is there any way to create an abbreviated process to validate the relevance of an objection without creating a full package? And this is from Tony Kirby and from Worcestershire. He doesn't need an answer now, so if that's too big, he's letting you off the hook a little bit to a later answer.
Okay, so I think, to be fair, I think I will just say that as an order making authority, you are also able to refer parties to the Lasham case, which those of you, I'm sorry, I don't have the immediate reference to hand, but I'm sure we can find it for you. So in that case, it's a situation where the objection was irrelevant, and so authorities are still able to do that themselves and to say we consider this to be irrelevant and to ask parties to withdraw. But obviously, as you say, Tom, you're not able to sorry, Tony, you're not then able to actually, if they won't withdraw, you have to submit it through. It's not something that's been asked before, and I think, Harry, the best thing is that we can take that away and just have a think about that, because there may be implications either way. So if you can leave that with us, we'll consider that one. Thank you.
Yes, I agree.
Great, thank you. The next one is, can I ask the reason for the OMA having a shorter time frame for their statement of case than other parties, especially when for written representations, there is a chance to comment on each other's statements later in the process anyway. I struggle to see any advantage on the OMA statement being received earlier.
So I think, and correct me if I'm wrong here, Heidi, I think that's a confusion between the statement of grounds and the statement of case. So the deadline for the statement of case is the same for all parties. The distinction is that order making authorities don't have to submit a statement of case if they don't wish to, because they have already submitted a statement of grounds as part of their original submissions. The reason they come in earlier is because that is in effect the point at which it's the trigger point, if you like, the point at which the whole process begins is when we receive the referral from the order making authority. So just to be absolutely clear, the deadlines for the statement of case is the same for all parties, including the order making authority. The difference is the order making authority also submits a statement of grounds and do not have to submit a statement of case. I think I've got that right, haven't I, Heidi?
Yes, you're right. And actually, it's a good point for those who've perhaps not done a lot of submissions previously, that your best bet can be to do your statement of grounds with an eye to that this would be your statement of case. And then it's in early, and you can say when you submit it, this will also be our statement of case. You might still get a letter from us saying, can you confirm that whether you're sending a statement of case, but certainly you can say at the submission stage, our statement of grounds forms our statement of case, and then you don't have to bring it forward any further. The situation where an authority is neutral, so therefore you will have submitted the case, but then we might be looking to an applicant to lead. We may then at that stage be asking an applicant if they can submit things earlier than the usual statement of case deadline, to give other parties a chance to refer back to their statement of case. So that's where there's sometimes a difference, but that shouldn't affect an authority. So hopefully that will help you if you're thinking, oh, I've got to do something quick. Do it at the outset. So think about when you're writing your report to your committee or your decision maker, how are you writing that report, putting that together, and that could come through as your statement of grounds, and that could come through as your statement of case. So save your own work as well as everyone else's.
Great, thanks, Heidi. A couple of votes for this one. Can I ask why appendices submitted by parties that are not from the OMA are being passed to the OMA with redactions now? That's not been the case in the past.
I mean, I suppose that depends on what you are referring to by the past. I think certainly since the change in data protection regulations and the introduction of the data protection or the GDPR, can anybody help me out when that was? 20. Then issues of redaction are clearly more pressing, if you like, from a legislative point of view. And we do make this clear in our guidance that in certain circumstances we will redact documents, both statements of case, proofs of evidence, but also some appendices, if they give unnecessary personal information or in certain circumstances comments that we consider to be inappropriate. In such circumstances, we always go back to the party who has submitted them and say, could you please consider removing these details? So yes, I would say perhaps things have changed since the introduction of more recent data protection legislation, but I don't know if you want to comment on that, Heidi, or Rebecca, you could even offer a view from elsewhere in PINS.
Yes, I don't think this is restricted to this area of casework. I think, as you say, Harry, it's we are having to redact or asking the local authorities to redact any sensitive or personal information before it is published, and that's right across the board. It's certainly not just limited to rights of way casework.
Thank you.
Okay, a quick one, but it's had a few votes. Do you have preferred templates for SOC or SOG?
So there's not a template as such, but if I'm dealing with a a DMMO, my preference is always to see things in chronological order so that you can see the development of the route on the various mapping over time. If I was dealing with a public path order, then obviously I would want to see the route as it is now very clearly set out, the route that is proposed, any relevant photographs, and then you might need flood data or things like that. So not a template as such, but just making sure that everything makes sense, so that if you think about it, if somebody who didn't know anything about rights of way or anything about your case came and read your document, would they understand what you were putting forward? And I think that's a good judgment to use. Would they understand why you are referring to this particular document or this particular photograph? So I hope that helps. I don't know that we want to go down the line of having a particular template for the way that things are organised, but perhaps that's something that authorities or user groups might want to think about together and decide whether that's helpful to everybody.
Okay, thank you. The next one with the 5 votes here is the PINS backlog data. In the PINS backlog data, that there is a number awaiting primary validation and then secondary validation. What are the differences between the 2 validation stages, and how long does each take?
I can pitch in on this one, Rebecca. So the primary validation is done by our case officers. This process is really to do with checking that all the documents we would expect have come in with the submissions and there's no really clear or glaring omissions. The second stage of validation is done by our operations officers, and that is much more detailed and looking for some of the sort of errors that I referred to earlier, such as issues with notation, say, perhaps the use of the wrong subsection in the relevant legislation. But the 2 validation processes together also just form a sort of system of checks and balances, if you like. Having 2 different people looking at the same set of documents just allows us to make errors less likely. And in fact, I think illustrated by the fact, as I mentioned earlier, that we have only rejected 2 orders in the recent year. I think it shows that validation system is working well. In terms of how long it takes, and I don't mean to be mealy-mouthed about this, but it's really impossible to say. It depends on how complicated the submissions are, how long they are, how many documents have been included. It can be relatively quick. It can take a very long time.
Okay, thank you, Harry. For a DMMO applicant, what is the significant difference between a statement of case and a proof of evidence, please?
So your statement of case is where you fully set out your grounds as why you consider that an order should be confirmed, should not be confirmed, or should be modified. So in that document, you're going to have your reasoning set out, and you're going to attach your appendices, or even I've seen certain parties, and I like the way they do it. They may recognise it when I say that they put photographs, so they put snapshots of the maps within their document. So as you're reading through, you can see the map that they're talking about rather than needing to flick pages. So all of that information comes together in your statement of case, and that tells people where you're coming from and what your view is. Your proof of evidence will be what you speak to, if necessary, and if asked to, at the inquiry, and it summarises and pulls together your expertise. So you, for example, a case where we had involvement of a statutory authority who then wanted to present evidence on a safety matter. They had a safety expert and they had a mapping expert to talk about historic mapping. So the proof of evidence would speak to your expertise. Now, it might be that there's only you in the authority, and you're producing the statement of case and the proof of evidence, in which case effectively the proof of evidence just is again pulling together and summarising your statement of case. So it will depend to some extent on whether you've got more than one person who's giving evidence to the inquiry. The statement case is the whole, and the proof of evidence is the individual's expertise being brought to the fore. And just a reminder again that if you can summarise proofs of evidence, you must do so if they're over 1,500 words anyway. All right, so hopefully that helps. Don't know if there was anything else, Harry, that I might have missed in that.
No, nothing to add from me.
Thank you. I think that is all the questions that we have in the chat. Unless I've missed anything, I think that's.
I can see a question at the top, Rebecca, from Jeff around just legislation.
Oh,
Does
yes.
the legislation under which the order is made have any bearing on the priority it is given for consideration? So I can ask this quite straightforwardly, as we do prioritise Town and Country Planning Act orders because they often have planning permissions attached, if you like. And so we do prioritise them on the understanding that there may be a time frame that we need to bear in mind.
Okay, great, thank you. And a few more coming in now, and I've refreshed this. Where a county council, who are the highways authority, are acting as an agent of an OMA or an LPA to process a section 257 TCPA PPO without a formal transference of powers, would PINS expect the OMA, district or LPA, to appear at an inquiry or a hearing to make a representation to a written rep?
Sorry, I can't see that question. Could someone...
So, yeah, that was from Robert Lee, and that
Okay.
came in, so it's towards the top of the questions because it's coming more. I can repeat that. So it's where a county council, who are the highway authority,
Oh, I've got it now.
are acting as an agent. Yes,
Thank you.
quite a long one.
Okay.
Sorry.
And PINS. I think I might have to just take that one away. I'm just trying to read it on the fly, Robert, and I think it would be better if I just take that one away and just make sure I've understood what you're asking, unless Harry has picked it up much more quickly than I have.
No, I think that would be, I agree.
Yeah.
I think any answer I'd give would probably need to be revisited. So I think let's take that one away. I think, Rebecca, I can clarify William Barfoot's follow-up around statement of cases. So
Yes.
just for everyone's benefit, if you can't see, William has said, no, I do mean statements of case, and this relates to that question around, in fact, now that I'm engaging my brain here, I think this may be one we take away as well, just to absolutely clarify. So yes, just please leave that with us, William, and just to note that we can see, we note your further question and we can follow up.
Yeah, we will follow up on any questions that we've not been able to answer today. And we have one from Jeff Fuchs. Does the legislation under which the order is made have any bearing on the priority it is given for consideration?
Oh, that's the one we answered, Rebecca.
That's the one we got. Yes,
Yeah.
okay.
Yeah.
Great.
So there's one.
There's one more come in
the chat there. So you've detailed that every piece, and this is for you, Harry, you've detailed that every piece of evidence must be in a separate file. In the case where there are long tracts of relevant emails, for example, does that each one need to be separated out and individually referenced, or can they be compiled in individual date order, for example? I know what my preference would be. I'll see what yours is.
I suspect the answer is it depends. I mean, I think a document that contains a series of related emails in a Word document, say, rather than hundreds of separate emails saved separately, would probably be preferable. What do you think, Heidi?
Yes, I think that would be my preference, that it goes into one document in date order, and that would be much easier for people to deal with.
I mean, what we're trying to avoid is and I appreciate this is rooted in the fact that people are having to send things to us via email, and that makes transferring a large volume of documents difficult, which is why sometimes people go for this approach where you're collating everything into one large document. But it just makes it extremely difficult to navigate for case officers and inspectors if you just have everything in a very large PDF, say, or two or three large PDFs. So that's what we're trying to avoid. That's not to say that in certain circumstances you can't combine a few related documents, such as emails, say, into a Word document or a PDF.
Right. And I think it's not a question, but we have the case that was referred to earlier there, so thank you for that. You might have answered this, Harry, but we've got a question about an indication in months on the backlogs. How long is the time frame from submission and second validation?
Yes, so I don't have up-to-date figures to hand, but I think the most recent update we issued said that the backlog was between 7 and 8 months. This is a backlog that developed during the pandemic that we have been slowly whittling down since that point. We recognise that it's something that causes frustration for stakeholders, and we are working very hard to try and reduce that backlog. But I would say it remains around the 7 to 8 month mark as it stands.
Okay, thank you. And we might have time for one more, but where the OMA receives a letter of support for an order, this would technically be a representation. Can the OMA disregard this, as otherwise it would need to forward the order to PINS for confirmation?
So in this instance, they know you have a statutory representation, but what you can do is you can go back to the party who's made the representation and explain that theirs is the only representation, and presuming there is no objection, and ask them to withdraw it on that basis, and then you would be able to confirm the order without submitting it to us. I know this is a little bit more work for you, but at the present moment in time, we're not able to simply disregard statutory objections and representations. So I hope that helps.
Thank you. And there's a few more here just around venues for inquiries becoming more difficult to organise. How near to an order route should a venue be? And there was a little bit about the process for the OMA to be informed of the need for a hybrid inquiry, because of course it takes them longer to organise.
Well, on the latter,
so I think
sorry, Heidi, you go ahead.
Sorry, I was just going to say that I think we are coming to the end of our time, and so what we might have to do is take the other questions away, and we will respond to them. So don't worry, we won't ignore them, we will respond to them. But I think just time-wise, we are nearly out. Rebecca.
I think we are, aren't we? Yes. So please do. Thank you, for your time today, and we will pick up any questions that we were unable to answer today. We ran out of time, and thank you for attending and sending us those questions. There are some links here on the slide about further learning and information please do sign up for any alerts from us, because we do have some other webinars planned, including a forthcoming one on enforcement, the date to be confirmed. So yes, from behalf of me and the team, thank you very much for attending today. And as I say, we will try and follow up those questions that we didn't get around to answering. So thank you, everyone.